Welcome to Growth Fridays, this 1 hour workshop where we get to feed you what is possible in order for you to grow your business. In today's session, if we haven't met yet, my name is Brenda Kasuva, and you will be getting follow-up from us at the end of the session. You're welcome to join us and continue this conversation on social media or online. We also have our YouTube channel. I would like to say a big thank you, not only to those of us who are attending, whether you've attended a session with me before or not. However, today, the big thank you is going to our two guest speakers. We have the pleasure of having Brad Cox, who we volunteered together at GBBR. He's a member of the Legislative and Forms Committee. And Brad, I should have added Board of Directors as well, because that's where we connect most of the times.
Yeah.
So he's with Long and Foster Realtors. That's his contact information as displayed. And the other guest speaker that we have is Mark Feinroth from Maryland Realtors. His title is Director of Political Advocacy. His email address and contact information at Maryland Realtors. And when you take advantage as a member of Maryland Realtors, your membership does afford you to get access to the legal hotline, and their telephone number is displayed there, available on Mondays and Wednesdays. 2 hours, 10 to 12, and another 2 hours, 12 to 4. And I just saw that you added an extra hour on Fridays, 10 to 1. So sometimes you will get Mark today. He offered to do this session with us, and other attorneys are taking care of the legal hotline. We are going to give them the opportunity to start off with Brad sharing with us. Brad, take it away.
Thank you. So if you don't mind, I'll share my screen. Thank you, everyone, for attending. Brenda, thanks so much for the invitation here. Looking forward to speaking with you today. And just wanted to, Brenda asked me to go over some of the laws that are going into effect in 2022 and some of the kind of the wins and losses that we as the legislative committee experienced. So I'll go over that information, and if anyone has any questions, feel free to ask. The one thing that I wanted to put out there first was as a disclaimer that you're not attending a legislative update CEU class. This is just me talking about what's going on, and it's just informational and reflects the data available at the time here. And if I have any comments or opinions, they're mine and not GBBR. So there we go. So I just wanted to talk about how active the session was this year. We had a very active session. As you can see, 1,331 total pieces of legislation introduced by the Senate and 1,783 by the House. And the 783 bills that were enacted, that's just by the Maryland General Assembly. So it doesn't include those bills that were introduced by either Baltimore City or Baltimore County. This is just the Maryland General Assembly. So we're going to jump right in with some of the bills. So chapter 326, and I'll refer to it by the chapter now once it's been enacted, but it's also, I also referenced the actual House bill. This one, chapter 326, is about the irredeemable ground rents that's going into effect in October. And it requires SDAT to create an online registry of the properties that are subject to ground leases, and it requires the holder of an irredeemable ground rent to file a renewal notice of the intent to preserve that irredeemability. So first of all, you may have thought that all ground rents in the state were redeemable. There are, in fact, some that are irredeemable, but it has to be, the holder has to specify it as irredeemable, and they have to renew that on a regular basis. So this law just codified that a little bit more and specified some of the specific details.
So Brad, with that one, did they put like expiration or how often?
So the ground rent period, I can't remember the exact thing, but I can look that up pretty quickly if you want, or we could come back to that in a little
You
while
can
once we
come
get
back.
through the rest. Okay, so let's do that. All right, so the next thing was chapter 664 had to do with the condo co-op and HOA reserves that are maintained. And this bill was brought about in a lot of ways because of what happened down in Florida with the condos that collapsed there on the in the state, and they realized that there were quite a bit of condos and associations that had deferred maintenance on properties. And so this bill was passed so that they would make sure they had adequate reserves to make repairs to common areas in the buildings. And this is among other legislation that was being considered too, but it's a really important bill because there was a lot of deferred maintenance in not just Florida, but throughout the US. And it's been a big issue. So this is a step toward addressing that issue. Chapter 130, which was House Bill 203, is the Homestead Property Tax Credit Program. And it should be, everybody should know, but there's the Homestead Property Tax Credit, and then there's the Homeowners Property Tax Credit. The Homestead Property Tax Credit is related to the property. Homeowners property tax credit is related to the homeowner. So this Homestead Property Tax Credit Program allowed for retroactive qualification and how the credit was calculated. So if somebody had failed to apply for their homestead property tax credit, we saw a lot of property appreciation over the past couple of years. And so what this bill did was it allowed them to go back, and if they had failed to apply previously, they could get retroactive qualification for that. Chapter 132.
I'm sorry, Brad.
Yes.
How far can they go back? I mean, sometimes you say retroactively.
1 year. They get 1 year. It's a 1 year look back.
Thank you, Mark.
Thank you.
You're welcome.
That gives them the 1 year. Okay, great. So chapter 132 is the application filing deadline for the homeowner's property tax deadline tax credit. And this allowed the homeowner to apply within 1 year after April 15th of the taxable year for when the credit is sought. So if they had applied previously in the preceding 3 taxable years, or if this was their first time, it would extend their deadline for applying for the homeowner's property tax credits. This is different than the homestead. This is the homeowner's income related tax credit for homeowners in the area. And this allowed them to a little more extra time to apply for that. And then there's chapter 112, the homeowner property tax credit identification of eligible homeowners. And this was actually a great, in my opinion, a great idea, because there were plenty of people, much like with the homestead property tax credit, there were plenty of people who didn't apply, didn't know they could apply. And what this bill did was it required the comptroller to go out and find those people based on tax filings to determine who would be eligible for that, and to notify those individuals through the STAT that they may be eligible for that, and encouraging them to apply. There were a lot of people who were just not taking advantage of that benefit. So this was a great bill to help them take care of that issue. Chapter 722, which was House Bill 521, landlord and tenant shielding of court records. And there's always a ton of landlord and tenant legislation that's proposed. This is just one of many of them. But we, in fact, opposed this legislation. It got passed, but we thought that the shielding of the court records put landlords at a disadvantage, because when you're screening tenants, if they were previously evicted from a home for failure to pay rent, this particular bill would allow, in some cases, for those court records to be shielded, and that would put those landlords at a disadvantage when they were trying to determine if they're a good tenant. So it's in effect, and we will see how it turns out, I guess. Chapter 649, which was House Bill 568. This one is probably near and dear to many of your hearts, but it's the real estate brokers and salespersons payment from the title service provider. And so a while ago, years ago, brokers used to be able to provide a distribution authorization to a title company, and at settlement, they would pay out to any number of different checks. They would pay out, here's the check to the broker, here's the check to the agent, here's the check to our foundation. You could have a number of different ways of splitting up the commission fees. And and then a few years ago, the real estate commission came out and said, nope, you can only pay the real estate agents through the broker. You can't pay them directly. And in fact, for a little while, there was kind of a knee-jerk reaction from some title companies because they somewhat misinterpreted this law. And if you maybe got caught in this, some title companies were saying, we can't even hand you the check for your broker at settlement, which got clarified, thankfully, and that got put to bed pretty quickly. But so there was a lot of back and forth. Well, this bill was introduced, and it was a Maryland Realtors bill. Obviously, we supported it with as much enthusiasm as possible. And this will allow us to go back to that distribution authorization so that the individual agents and or anything designated by the broker can be paid directly from the title company effective this year. Does that make sense?
And maybe Mark, you can add on if you'd like. This is still the broker's decision, right? Some brokers might decide, nope, I still want to get the check, and then I'm the one who's going to distribute it. The broker still has a choice.
Yeah, absolutely.
We always thought it was the broker's within the broker's capacity to delegate to the title company the distribution. The real estate commission took the position that the statute was very clear about only the broker has authority to pay the agent, that they didn't have an authority to delegate to the title company. But we clarified that with this legislation. So it's still up to the broker. And it's a courtesy that many brokers, especially small and mid-sized brokers, provide to their agents to get paid a little bit more quickly. When they're struggling with commissions and such, to cash that check a few days earlier is sometimes very helpful to folks.
Thank you.
Excellent. All right. Chapter 333, which was House Bill 807. This was another Maryland Realtors bill. The CE courses verification of identity, which we went to a lot of online classes, and it got to be a little challenging for the people who are administering the online classes to get people to hold up their ID in the middle of the class. And, there was concern by a lot of agents that, hey, I don't want to hold up my driver's license that has sensitive information in it in the middle of this class and let everybody else see that. So this bill allowed them to handle that through an affidavit attesting to the identity. And it also, because they submit that affidavit there, they are attesting that they are the individual who is taking the class. So, there's a higher degree of accountability that the individual who said they're going to be attending will be the one attending. So any other points or clarification on that? Anybody want to?
Yeah, sorry. So I think the other question that has come about with this one for schools, is it per class or per individual? So if Brenda is going to take 6 classes with the school in the next year, will she need to sign it every single class?
Mark may need to answer that question. I'm not certain.
So I don't think the real estate commission has taken a position on that yet.
Right.
My guess is they're going to require it each and every time. They got forced into this remote CE stuff because of the pandemic. They never would have proceeded with remote CE, on their own, because they've had inherently been suspicious of the idea of licensees not really paying attention during remote learning, and also they've been concerned about this identification issue. Having someone other than the true licensee who's seeking credit actually sitting in front of the computer getting credit for the class. So they've been a little suspicious of this technology stuff and the identification issues. So I suspect they're going to be a little bit more, at least for a while, a little bit more strict about requiring it each and every time.
Thank you.
Thanks, Mark. Okay, so chapter 195, and this one was kind of a real good, feel-good bill, which was HB 807, which was the property tax exemption for disabled veterans, active duties, or surviving spouses, which allowed SDAT to accept an application for the property tax exemption for a specific house, even before the individual purchases the house, and then requiring the department to process that application quickly within 15 days and send a letter regarding preliminary approval, which helps with loan qualifications and things like that too. If you don't have property taxes that you're paying because you get this exemption, then that can allow you to qualify for more of a property. So that's a great tool for our veterans and their families. Okay, chapter 336, which was HB 927, affordable housing, excess real property. I think everybody acknowledges that affordable housing is a challenge in general across the country, and even especially in our area. So there's a lot of vacant property and property that's owned by municipalities. What this forces them to do is the Department of Planning has to provide a list of the excess real property owned by the State Department of Housing and Community Development, and then they have to determine whether any of those properties are suitable for use or redevelopment as potential for affordable housing. There's a lot of legislation and discussion about what to do with Baltimore vacant home issues. As you probably know, things that have come up lately with the firefighters and the police, and whether property should be entered and how that property is being used now. So it's a big issue, a big challenge for the city, and this was a big step forward in helping to identify those properties that could be redeveloped and we could take advantage of them for some more affordable housing. Okay, chapter 502. The Maryland Personal Information Protection Act, some revisions to that. This was a bit of a concern for us as well because it added some significant requirements on entities who would receive and or maintain, not just own the data, but even if you had to maintain that data, a lot of requirements on securing that data, and then if there were any breach notifications, identifying that a breach had occurred, and then how quickly those individuals who may have been impacted by that breach have to be notified. And it can affect the individual agent in this situation if you are maintaining any sensitive information from your clients. So this bill puts a lot of extra onus on business owners, and so we're going to see how it shakes out, but it is going to be enacted. I would just encourage you to discuss this with your brokers, determine a plan for securing data, and trying not to maintain any sensitive data if you can afford it. If you don't have to take somebody's social security information, great. Don't, try not to hold on to copies of any of that stuff, because when you do, you're just more exposed to this kind of issue. Chapter 654, House Bill 1097. This is a huge win for fair housing. So this was a big issue, and we supported it. Creating this task force on property appraisal and valuation equity. Many of you probably know there's been a lot of studies over the course of the last several years about appraisal inequity in disadvantaged communities, and with that going on, this task force will start to look at those issues and try to at least shine the light on them so that a plan can be created to address those issues. It's a huge problem. I can't remember, Brenda, you might remember the reporting that was done where they had the one family that was an African-American family, and they had some ethnic things in their home. An appraiser came in, valued the property at a specific amount. Then they swapped out any of the contents, just the contents of the home, nothing structural, no paint, no, just the furnishings and things, the artwork, and put a white woman in the house, and the property, then they had a property reappraised, and the property appraised for more money. So it's a huge issue, and this was a big win for that particular issue. Chapter 86, which was House Bill 1110, lead poisoning prevention, the elevated blood level for lead. That number has been dropping year over year for the past, many years since we were starting to deal with lead paint issues, and it's gotten down to an almost imperceptible level of lead, which is phenomenal, I think, because it's just creating that protection for families that are may have issues with children or anybody that could be suffering from lead-based paint issues. It does change some of the notifications and lead risk reduction requirements, and it lowers that level of blood lead that initiates those particular things to a much smaller portion. I can't remember the exact unit of measure. Mark, do you happen to remember what the unit of measure was on that?
No, I don't.
Yeah.
I'm sorry, I don't. But I mean, like you say, the lead paint issue, lead is such a toxic substance, especially for developing brains and minds. So the public policy initiative and the urgency of it has always been to drive down that number as low as possible. The number of exposures very low per year. Very few children every year testing positive for lead exposure. But if even a very small number, those implications are very, very long term. It's a permanent disability that these children are sustaining from lead exposure.
Absolutely, and well said. And if we can protect any children, and even as the number, as Mark indicated, has been dropping precipitously, any child that's exposed is a possible child we could have prevented that from happening to, and it is permanent. So yeah, thanks, Mark. Okay, Chapter 267, House Bill 1186. This is another kind of feel-good bill that really did some nice things for elderly individuals and veterans, tax credit. The amount and duration got changed with this bill. So it used to be that the city had very specific timeframes involved and dollar amounts involved on the type of property that could be receiving the tax credit. With this bill, they remove those requirements. So the property can be a little more expensive and they can still get the deduction. And it allows the city to specify on a case-by-case basis what that duration should be. So it was an improvement of the existing law to create a little bit more freedom and discretion to cater to individual needs. Chapter 34, which was, now we're getting to some of the state bills. And a lot of these bills, by the way, are cross-filed between the House and the Senate. And I didn't always mention, it's House bill this, Senate bill this, but a lot of them are cross-filed. But there were some of these bills that were done by the Senate. I chose to mention them in the Senate because they're bigger bills. So this Tenant Protection Act of 2022 is a very big bill. There's a lot of content in it, but as you can see, it deals with a lot of different things. So if the landlord uses this ratio utility billing system, meaning that he doesn't, you don't have a meter on each individual unit, that there's a single unit and then there's a calculation used by square footage or whatever criteria that the landlord sets. This requires that landlord to disclose to the tenants, if they're using that type of system, how that calculation is determined. And if they don't provide that disclosure, it makes that lease unenforceable. It also requires them to provide documentation for bills that they've received for those utilities. And it's also done some things for tenant organizations. So if they want to assemble in the property to discuss issues, this allows them to freely assemble in the property as long as they give reasonable notice to the landlord. And it also includes some stuff on victims of stalking. So there's a ton of things packed into this Tenant Protection Act. And in fact, Brenda mentioned she was going to put the link up there for the Maryland Realtors legislative summary. If you search for that bill, you can click, there will be a link on there that will take you to the Maryland General Assembly site. And if you go to that site, the link will take you to the individual bill, so you don't have to search for the bill. But when you get to that bill, you click the down arrow on the history and you'll be able to see all the versions of that particular bill, including what was finally adopted, which is down at the bottom of that list. And you can go and read the contents of the individual bill. So lots of stuff in these bills, and I encourage you to review them, but a lot of protections for the tenant in these in this bill. And Chapter 38, which is State Bill 528, this Climate Solutions Now Act of 2022, required the state to reduce greenhouse gas emissions, setting goals, going to a net zero goal at some point, developing energy efficiency and emissions reductions. It has to do with, specific types of buildings. And that was actually our concern. This is a pretty costly bill to implement, and for the property owners as well, more commercial properties than residential. But there's a lot of money that will need to be spent on certain buildings, and it'll make construction of new commercial properties a little bit more expensive. But in general, it is an overall climate protection act, and the state felt that that was a necessary step to take. So there's a lot of things, again, in this one. It's a big act. I would encourage you to go to that bill as well and look at the contents and suss out the details. All right, this one wasn't really talked about on the Maryland Realtors site. So you won't see this in that link, but you can search once you go to those. If you click any of those links from the Maryland Realtors list, you can actually go type in SB space 557, and you can search for any bill that way. You'll see this West Baltimore County Redevelopment Authority bill, and it's now Chapter 17 adopted by the county. And this was a big win for us locally, because at GBBR, we looked at this bill and there were major concerns with regard to how the bill was worded, because they were investing in the West Baltimore County Redevelopment Authority eminent domain power. And our feeling was that that was a big overreach. That particular power should stay with the county rather than with an individual authority focusing on a particular area. The idea of the redevelopment was fantastic, and we certainly supported that, but that eminent domain power was a huge concern for us. So it was great, actually. We, through our lobbyists, communicated to the bill sponsors, Senators Sidnor and Kelly, that we had some major concerns about the bill, and they asked to meet with us, and we got on a Zoom session with them and kind of outlined what our concerns were. And it's a big swath of land, and in this particular market, with that eminent domain power, we were really concerned about what the optics would be like too, because you don't want to talk about eminent domain and exercising that stuff in a super difficult, challenging market where anybody who might be displaced needs to find a new place to live. And so we had that conversation with Senator Sidnor. They agreed, and they struck out the eminent domain power and put that back with the county where it belonged. And then we were happy to support the bill as it was amended. So that was a huge win for us and our PAC dollars at work. So if you ever wonder why you pay your association membership, that's one of those things. It was a big win for us. So we were pretty excited about that. So some local stuff. There's some city bills, some county bills that are out there, and we're not going to get into all of them. But this City Council Bill 22-0093R was a request for state action, stability for renters. So they were just looking for, in a very challenging market, some of the bills that were proposed, HB 881, 672, 724, 703, and 691, which of course you can go read at length if you'd like. But all of those bills, the city council felt like they needed to specifically ask the state to consider and sign those pieces of legislation immediately. So, it was kind of a symbolic gesture, but it's an important concept right now. Challenging time for renters with rent going up, and with COVID getting out of, kicked out of the house was a challenge. So they were looking for that stability. And not all these bills were passed, signed into law, but the city was specifically asking for that. So there is this Baltimore County bill. This one was passed, 14-22, abatement of public nuisances. So there's always been nuisance law in Baltimore County. This changed the process a little bit, creating a different standard for evidence of public nuisance, kind of made it a little less reliant on a conviction and allowed for a looser interpretation of the public nuisance to police reports. And if there were multiple police reports of public nuisance at a particular property, it wouldn't create a fine for that particular homeowner right away, but it would force a hearing on that public nuisance issue. And it also sets forth the property owner's appeal rights. But we've had a lot of issues with public nuisance properties in the state, in Baltimore County, things relating to gambling, to drugs, to prostitution. And this helps to abate that and allows quicker action to be taken, which helps the other homeowners in the area with, maintaining their property values and quality of life. So good thing. 22-22, and this was also done on a statewide basis. You probably are aware, as part of the census every 10 years, we look at the revision of our representatives' districts. And I didn't put the state districts up there because that would be almost a meaningless map, hard to really see all the individuals there. But I did put Baltimore County up. This is the new map as proposed by Baltimore County for the new councilmanic districts, and that was adopted. One of our members actually facilitated the effort to look at the redistricting effort. That was a critical effort and a lot of hard work. And there were iterations of this. There were some concerns with initial boundaries, and they got reevaluated. And there's a final proposal. So going, in the October timeframe, the new districts will take effect, and you may have a new representative. I know for my district, we're moving from a Republican to a Democratic representative. So it's a change in general, but it hopefully the newer districts are a little bit more logical, because there was a lot of concern about gerrymandering in general, and some of the districts just looked incredibly odd. At least the map looks a little more intelligent now. All right, huge one here that I just had to share at the very end. This one was effective February 1st, so it's already in effect. That's how serious this was. But the county previously had a rule that if you wanted to have chickens, you had to have at least an acre of land. And now you don't have to have that acre anymore. You can have a smaller plot of land and still have your chickens. So you can have hens on smaller properties. You have to have a license. You have to live where those hens are kept, and you have to have a coop, and you can't have roosters because of the disruptive nature of them. But the new chicken law is in effect. So congratulations, Baltimore County. You can have your chickens. Thank you. All right. So that was kind of a funny one. But the point that I wanted to drive home with a lot of the things that we talked about in the bills that were considered. We did a lot of work. The legislative process, when we look at things from a legislative committee perspective, these bills get examined from January to March. We are meeting every single week. On Friday, we get a list of bills that we're going to consider. We have to read those bills before Monday, and then we meet on Monday to discuss them and decide how we're going to react to them. And we can either support or oppose them at any number of different levels. That may involve something as simple as a statement that we are in opposition, all the way up to active testimony and lobbying of individual members of that, the bill sponsors, and all the representatives that could be voting on it. So there's a lot of consideration that goes on with regard to how we respond to these bills. But this is your RPAC dollars at work, because our lobbyists, they're not a Democratic Party, they're not a Republican Party, they're the Realtor Party. And so if you are an RPAC member, I thank you for that. If you're not supporting it yet, I'd love for you to consider making it a part of your business. And if you have any questions about that, we can certainly try to get you some answers. And that's what I have.
Thank you so much, Brad. Thank you. Any questions for Brad? I know you might have some, but hopefully we gave you some direction as to where you can go get more information. Thank you so much.
My pleasure.
Thank you very much. That was terrific, Brad. And thank you very much, Brenda, for inviting me to talk to the group today. So Brad's presentation was very comprehensive. I have a few bills to add to the bills that Brad talked about, and also a couple to talk about that we didn't get, two that were good that we didn't get, and two that we will try again to get in the future. So let me just start with those at the beginning. Policy positions that the Maryland Realtors took early on prior to session that we were pursuing that that we were disappointed about. One was on accessory dwelling units, a major piece of legislation that we pursued. That's going to, I think, be a multi-year effort trying to bring along the municipal governments and the county governments. And the idea here is simply to try and work hard to do something about the supply side issues in the rental and sale community in the marketplace these days. We all view, I think, very, very consistently view the increase in prices statewide at the state level and for both rental housing and sale and rent and properties for sale. The supply issue being the largest one. Too many buyers chasing too few properties.
Mark, wasn't that, was that Mary Washington's bill?
That was, I think, Belcastro's bill.
Okay.
I believe. So that was House Bill 1259. I think it was Lisa Belcastro. I'll have to take a look at who the sponsor was.
Okay.
But important piece of legislation that we did not get passed out of the House of Delegates that we'll be trying again next year. We faced pretty significant opposition from the Maryland Association of Counties and the Maryland Municipal League. Those are the folks that represent the towns and counties of the state of Maryland. And they came in and they said, gee, they didn't want to be told by the state that they need to work harder to do more with these kinds of housing in their communities. They insist on local autonomy on the planning and zoning issues. They did not want to be told that this is an important prerogative of the state to start encouraging and pushing those kinds of programs to try and increase the housing stock. The trouble, of course, is whatever the counties and municipalities are doing to increase their housing stock, it's just not fast enough. They're not doing enough to increase the housing for the units that we really need. But so that's something we'll try again next year. Another piece of legislation that we pursued on the brokerage side that was really, we thought important that we'll have to try again next year. House Bill 720 was on termination of real estate contracts. And that's an issue we've kind of been talking about for more than 2 or 3 years now. We came forward with legislation this year proposed by the Maryland Realtors with private sponsorship. And the idea here is that when buyers have an irrefutable right to terminate contracts, sellers sometimes refuse to sign the mutual release of the deposit, and they tie up the deposit money even though the buyer had an unquestioned right to terminate the contract, sometimes with the HOA, a document review period, sometimes another contingency simply wasn't performed properly, and the buyer has a right to terminate, but the seller declines to sign the mutual release of deposit, and the earnest money deposit ends up getting tied up for a period of time. Really unfair to buyers in this market because it's so difficult to find properties, and they're making offers sometimes on more than one property, or repeatedly making offers on properties to try and find a house to purchase. So that's one we'll pursue again next year. Those are two that we were disappointed about not getting. Go ahead.
Hey, Mark. Yeah, I was just wondering, where was the opposition on that one? Where did it come from? Do we know?
That was coming from lawyers on the committee who were concerned about the idea of automatic operation of contracts and terminations. That was something that we were going to have to spend a little bit more time with the bar and lawyers on the Judicial Proceedings Committee on the Senate. All right, so those are two we didn't get that we really wanted to get, two that we didn't get that we really are happy that we didn't get, that were vetoed by Governor Hogan and may be coming back when the General Assembly reviews vetoes and considers vetoes. They're both landlord-tenant bills. Both of them offered by Senator Hettleman from Baltimore County. One was vetoed by Governor Hogan. It was providing for a 30-day stay of eviction when the tenant has proof that they've applied for rental assistance. So an automatic 30-day stay of eviction if the tenant can demonstrate that they've applied for rental assistance. And the other, vetoed by Governor Hogan, will require a landlord to provide evidence of their rental property license if they're in a jurisdiction where a rental license is required before they can file their eviction complaint against the tenant. So again, legislation vetoed by Governor Hogan that will be taken up by the General Assembly when they return to consider vetoes. And there were two or three other small bills that I wanted to mention that were enacted that may have interest to the group. There was legislation adopted on commercial historic revitalization and the enterprise zone tax credit, and that was expanding the tax credit so if you're in a commercial situation and considering historic revitalization or the enterprise zone, that program has been expanded and improved. That's a good thing. That's something we were happy about and supported. And there was one other that I kind of started on my list that I wanted to go back and mention. Oh, the on-site wastewater services registration and regulation program. That's going to be effective July 1st. We were already facing a requirement for licensing for individuals who inspect septic systems prior to a transfer. The larger regulation program will be effective this summer as well. That's House Bill 318, signed into law this past spring. So that's where we are. Those are the bills. Brad's presentation is so comprehensive that I only had a few more to add to it.
Hey, Mark, thanks. I wanted to ask you real quick, the one that I guess neither of us mentioned was the removal of the buyer's names from the contract. And it occurred to me, and that was one that was not passed, was put together by, there was a real estate broker involved in the creation of that. And that was not passed. I can understand the impetus for it. There was fair housing concerns that people were being discriminated against on the basis of their name. So the idea would be that if you remove the names from the contract, that would be, a way of discouraging that or eliminating that discrimination. However, I think we all agreed and tried to oppose that legislation because we felt like there were better ways to handle that. And the way that they had written it, it was also an optional thing. So if a buyer chose to have their name removed, they could elect to do that. But in fact, then we thought, what is that going to communicate to the seller? It's going to communicate that, oh, well, this is somebody I should maybe be concerned about. What are they trying to hide? So it was either going to have to be across the board or not at all. And we felt there were better ways to handle that. So we opposed it, and it did not get passed. So we were pleased to see that outcome. That may come back too, but
yeah, the lawyers were very worried about how you get to a place where you have a real contract agreed to and entered into between two parties when one of the parties is unknown. You don't even know who your buyer is. So we were concerned about contract formation issues there. And I'm trying to think, there was one other bill that I had in the back of my head I wanted to mention. Love letters.
Oh, yeah.
The likelihood is that the realtors will be coming forward again with love letters legislation, trying to make that either restricted or prohibited, one or the other. And the current concern there also is a fair housing issue. We've been preaching against love letters for 2 or 3 years now. And the national realtors have taken a similarly kind of aggressive stance on it to kind of oppose love letters because of their fair housing implications. There's almost always a fair housing issue involved in one way or another with a love letter, whether it's a picture of the family or a picture of the buyers or some expression of why they're interested in the particular property. It's almost always going to implicate a fair housing concern.
And Mark, to your point on that, we thought we had great momentum going with the Oregon law that got passed. And then a federal judge struck down that Oregon law right after our bill was proposed. And so our reaction, the legislation's reaction to that was to, basically kill that version of the bill. I think the challenge, and again, this is my own personal opinion, but is that it was too broadly worded because it stated that you couldn't convey any personal information about the buyer. And I felt like if it had been worded, and this, again, I'm not an attorney, I'm not a legislator, but if it had been worded to say you may not convey any information about the buyer that is specifically prohibited by protected classes or that it impacts protected classes, that would have been a harder issue to say no to.
Right, I agree with that. And on the appraisal task force legislation you talked about, Brad, we're tracking through the Maryland Human Relations Commission the progression of a few initial appraisal bias complaints that have been filed. None have gone all the way through to full adjudication. So we don't really know their status and what, how, whether they were, creditable complaints or not. But there have been complaints filed alleging appraisal bias, and we're watching to see how they mature.
Great. Thank you, Mark.
Thank you. In review, without assuming with the love letters, so what we're talking about is we as Maryland Realtors already have it in the contract that we're using. However, the discussion of the law is where we wanted it to impact everyone that has a real estate license. So just to give you a point of reference, we are about 49,500 of us that have a real estate license and about 30,000 of us that are Maryland Realtors. So the law that we're talking about that did not pass was to make sure everyone that has a Maryland real estate license does not participate in love letters. For now, if you're a member of Maryland Realtors, it's already part of our agreements with the buyers and the sellers. So we're following that, which says, again, we're not going to present it to the other side.
And unfortunately, that's still happening, but at least it is in the buyer and listing agreements.
Yes, thank you. Any other questions, comments, feedback?
I just want to make them aware that at least in my experience, names on both sides, the buyers and the sellers, has an impact, a real impact in the field. People make assumptions by names and it affects their selling or buying decisions. So,
hey, Steph, and if I may just comment on that, Stephanie, I agree with you. I think that's a big concern. I think, like I mentioned when we were talking about that particular bill, there just may be better ways to handle it than just removing them entirely from the contract. So I've been talking to Kathleen D'Artez at Maryland Realtors for a while on this, and there's a little bit of conversation going back and forth in general, but with the way that offers are presented, it's a little bit of a challenge. But I think if we could get to the point where we slightly change our rules on offer presentation to allow for an initial presentation without names and dealing with salient facts only, and then if we could come up with a standardized form, at least that's what I'm pushing for, but I'm one person, but we'll see. But if that could happen, I think that might be much more conducive to letting someone make a decision without having seen any of the personal information and then seeing the whole contract after they've made the decision.
right. Thank you.
It's a good
Thank
one.
you.
Yeah,
Yes.
I agree 100% because we do it when we submit the offer anyway. If you provide a cover sheet, you do a synopsis of what the contract says. So why give them the contract until they agree on that, and then you give them the contract?
Yeah, and I think the only way for us to get to the point, that's another great point, Deirdre. I think the only way for us to get to that point is to come up with kind of an established and codified, here's the form that we'll use for that, and here's how we process that, and here's the rules for administering that particular thing, that particular way of presenting offers. If we don't have that specified, it could probably get a little bit too out of hand. But yeah, that's what I would like to see. I'd like to find a way to come up with a summary of information that's just the salient financial and terms details of the contract, and then have them make a decision from that, initial that maybe, and then they get the full contract to sign.
So the counter to that is that real estate agents and brokers are in the habit of making such a mess of offer and acceptance. And we get so many calls and complaints and issues on legal hotline that adding another step or two steps to the offer acceptance when there really is no such thing as a ratified contract in Maryland law really gives lawyers like me and Kathleen pause. So that would make it harder, much more complicated to get to yes, we've got a contract, and that makes me really worried.
Yeah, Mark, I think your point is right that you can't do it without presenting the full offer. But I think there may be ways to handle it. Yeah. But it's a further conversation that I just think needs to occur.
Yeah, I think it's fraught. It's fraught, and I worry about it a lot. But all fair points. And one of the other things, Brad finished his comments about RPAC, and RPAC is about half of what I do at the office. I run the political action committee for the state and assist the locals with their fundraising and their disbursements. I should tell you that we have today informed the gubernatorial candidates which candidates the Maryland Realtors Political Action Committee will be supporting in the primary. So that's kind of hot news that you may be interested to hear. On the Democratic side, the trustees preferred and support Wes Moore for
Yes.
governor.
Oops, sorry.
Oh, was that a happy yes?
Seemed like it.
Yes.
Yeah. He really did impress the trustees very significantly. And then on the Republican side, Kelly Schultz will be the Republican candidate that the trustees support in the primary. There's no decision yet as to whether the association will make an endorsement. Right now, these are just expressions of support. Those candidates will be receiving financial contributions from the trustees, from the RPAC direct contributions.
Mark, thanks for saying that, because I should talk about GBBR's policy on that too. So GBBR interviews all the political candidates, or a good number of the political candidates for office in each election, and we talked to as many of them as we possibly can. I think we had 68 on the list this year. It's quite a few, and we tend to give money to everybody, but there are some that we will give a little bit more money to, but we do not endorse specifically. We found a few years ago that we endorsed the losing candidate in a mayoral race, and we were kicked out of that mayor's office for a number of years, for the length of his term, basically. And access is the thing that we need most of all. We need a seat at the table. And so we, in general, at GBBR, don't endorse a particular candidate, but we will support some a little bit with a little bit more financial.
Thank you. Thank you. Thank you so much for sharing. The challenge out there is get involved. Maryland Realtors volunteer applications are up on their website. You're able to go, it's displayed right now, and sign up. For GBBR, you will normally get an email under the one that's we normally get on a weekly basis. Sometime, Brad, oh my goodness.
Need to know?
Yeah. When do we get the opportunity to volunteer at GBBR?
Right, so that's coming up soon. I'm not sure, but you know what could be great is come next week to the Member Appreciation Week and ask that question.
Yes.
And that's going to be a great week. There's a lot of activities planned, and some great opportunities to get reduced costs on CE, some drawings and prizes and things, and you can potentially win discounts on your dues. So there's a number of things going on. Shred event, 2 days, I think, that week, and we've got food trucks coming in, and so it's going to be a great event. If you can come to that, that would be fantastic.
Yeah.
Hello,
Thank you all.
May I ask a question?
Sure.
Of course.
Yes, my name is Chuck Perry. I'm a real estate broker, and I'm also a member of GBBR. I'm wondering, the states of New Jersey and New York have been what they call lawyer states. Is there any reason why Maryland hasn't thought about doing that?
Because it would, in our view, reduce the impact of agents and brokers. So we've always taken the view that agents and brokers working with a form contract and a series of form addenda and contingencies are perfectly capable of taking care of a buyer and seller's needs in 95% of the cases, and that an attorney just isn't necessary. It adds costs and delays to the transaction, in our view.
Okay, thank you.
You're welcome.
Thank you for watching. You just completed a session that we offer through what we call Growth Fridays. They are offered every Friday at 12 p.m. Eastern. You're welcome to schedule and attend the next session on our website, trainingwithbrenda.com or brendakasuva.com. We have these 1-hour workshops that are available for you to attend via Zoom, walking you through different tools and strategies to grow in your real estate business. Lastly, subscribe for you to be able to get alerts of future videos that we upload here. Be successful. Take care.